Hello everyone. In the next four presentations, we are going to analyze the provisions pertaining to general exceptions contained in Chapter 4 of the Indian Penal Code. We have seen that the basic principle of criminal liability is that in order to amount to a crime, the guilty act has to be committed with the guilty mind. That is, actus reus and mens rea are the two essential elements of crime. Sometimes it may so happen that the act may be a criminal act, but the person doing it does not understand the nature of the act he is doing due to incapacity, mistake, etc. Sometimes, though the person knows that what he is doing is wrong, the circumstances may be such as to justify his doing the act. Thus, when an accused is prosecuted for the commission of an offence, he may plead that he lacked the necessary mens rea or the circumstances were such as would justify his doing the act. These conditions provide exceptions or defenses to an accusation of crime. Under the Indian Penal Code, Chapter 4 includes all the situations which, when proved, would exempt an individual from criminal liability. The chapter consists of 31 sections running from Section 76 to 106. Section 6 of the Indian Penal Code is the key to this chapter, according to which every definition and every penal provision and every illustration to such definition or penal provision has to be understood subject to the exceptions contained in Chapter 4, and these exceptions will not be repeated for every offence. These provisions also apply to the offences under special and local laws as specified under Section 42, wherein the term offence is defined. Broadly speaking, the exceptions constitute two classes, excusable acts and justifiable acts. Under excusable acts are grouped those exceptions where the person would be exempted from criminal liability due to lack of mens rea, mistake of fact, accident, infancy, insanity, and intoxication fall under this category. Under justifiable acts are grouped those exceptions which exempt a person from liability because of the existence of circumstances which would justify the doing of an act, knowing that it may cause injury to others. Judicial acts, acts done out of necessity, on consent, in exercise of right of private defense, or under compulsion are included in this category. The rule of evidence in criminal prosecution is that the prosecution, that is the state, has to prove that the accused had committed the criminal act with the necessary mens rea. Therefore, the burden of proof in criminal cases is on the prosecution, and the prosecution has to prove the guilt of the accused beyond reasonable doubt with the help of direct or circumstantial evidence. And if there is any reasonable doubt regarding the guilt of the accused, the benefit of such doubt has to be given to the accused. But when the accused wants to bring his case within any of the exceptions contained under Chapter 4 of the Penal Code, the burden is upon the accused to adduce evidence to that effect. Here, he need not prove beyond reasonable doubt that his case falls under an exception. If he tilts the balance in his favor, it would be sufficient. Thus, the burden here is no higher than that which rests on a party to civil proceedings. Now coming to various defenses provided under the chapter. Sections 76 and 79 deal with the defense of mistake of fact. The common law principles, ignorance of law is not an excuse but ignorance of fact is an excuse, have been incorporated under sections 76 and 79. The justification for exemption from criminal liability on the ground of mistake of fact or ignorance of fact is that a man who is mistaken about the existence of a fact cannot form the necessary intention required to constitute a crime and hence cannot be held liable for the act. But mistake of law or ignorance of law is not a defense because all persons resident in a country are bound by the law of the land and hence are deemed to know the law under which they live. If ignorance of law is allowed to be pleaded as a defense, it would be open to the accused to take the plea and it would be impossible for the prosecution to prove that the accused knew the law. This would result in the acquittal of the accused in every case, and administration of justice would become next to impossible. Regarding Section 76 and 79, Section 76 deals with cases where a person, due to mistake of fact, in good faith, considers himself to be bound by law to do an act and does the act causing injury. Section 79 deals with cases where, by reason of mistake of fact, a person considers himself justified by law to do an act in a particular manner and does the act causing injury. In both these cases, the accused will be exempted from criminal liability on the ground of mistake of fact. Mistake here must be nurtured in good faith, and under Section 52, good faith is defined according to which nothing is said to be done in good faith if it is done without proper care and attention. Thus, there must be bona fide belief in the existence of facts which, if they do exist, would make him innocent. If you recollect, in R versus Tolson, Mrs. Tolson married believing that Mr. Tolson was dead. He was alive, came back and prosecuted her for bigamy. It was held that the case fell under mistake of fact. In State of Maharashtra versus Mayor Hans George, George carried gold as transshipment cargo without specifying it in the manifest of the aircraft. When he pleaded ignorance of the change in position of law, it was held that mistake of law was not an excuse, or ignorance of law was not an excuse. And therefore, mistake of fact is an excuse, but mistake of law is not an excuse. Now coming to the next defense, acts of judges. Section 77 and 78 grant immunity to judges and those who carry out their orders from criminal prosecution. Section 77 provides protection to a judge in respect of acts done in discharge of his duty. Even where he does an act exceeding his jurisdiction, he would be exempted from criminal liability provided he believed in good faith, that is, after exercising proper care and attention, that he had jurisdiction to do the act. But where a judge knowingly exceeds his authority or does something which is illegal, exemption under Section 77 will not be available to him. Section 78 provides protection to officers acting under the authority or on the orders of a court of law. Even here, an officer would be exempted from criminal liability if the court issuing the order had no jurisdiction to issue such order or the order was erroneous. Here again, the officer must have acted in good faith, that is, he must have exercised proper care and attention, despite which he did not know that the court had no jurisdiction or that the order was erroneous. Next defense is accident. Section 80 states when accident becomes an excuse for criminal liability. Accident is an unintentional and an unexpected act. When an effect is caused by an accidental act, evil intent cannot be imputed to the doer because an accidental act is not his act. He did not will it and hence he is not responsible for it. In order to bring a case within Section 80, it has to be shown that the act was an accident, that it was not accompanied by criminal intention or knowledge, that it was an outcome of a lawful act done in a lawful manner by lawful means, and that it was done by exercising proper care and attention. Example, when A was cutting overhanging branches in his garden, the head of the hatchet flies off and injures B, the neighbor, who was watering plants in his garden. A will not be liable for injury because it was an accident. If the head of the hatchet was loose and A did not check the same and started cutting branches, he would not be held to have exercised proper care and attention and hence would be liable for the injury. The next defense is necessity. Section 81 gives legislative sanction to the principle that where on a sudden and extreme emergency, one or other of the two evils is inevitable, it is lawful to direct the event in such a way that only the smaller evil occurs. It permits the infliction of a lesser evil in order to avoid a greater evil. This defense is based on two maxims: necessity knows no law, and what necessity forces, it justifies. In order to invoke Section 81, three conditions have to be satisfied. The act must have been committed in order to avoid other harm. The harm to be avoided must be such as to justify the risk of doing an act likely to cause harm, and the act must have been committed in good faith, that is, by exercising proper care and attention and without any intention to cause harm. For example, where A is driving his car on the road and suddenly his brakes fail. He could not bring his car to a halt, and therefore, in order to avoid hitting a school van with 10 children, he hits a pole on the footpath to bring his vehicle to a halt, and while doing so, hit a pedestrian and caused grievous hurt to him. Here, though he knew that he was likely to injure a pedestrian if he has to hit the footpath, he did so only to avoid colliding with a school van consisting of 10 children. If the failure of brakes was all of a sudden and not because of his neglect to service the vehicle, even after knowing that it is not in proper condition, he would be exempted from liability for causing grievous hurt to the pedestrian under Section 81 Indian Penal Code. Thank you.